Yes, sir.
What's up, guys?
Yes. This DJ will kick the floor in 3, 2, 1.
On the troll.
Hello and welcome back to Mzansi. We are back again, which is that time of the night where we have to talk about what is happening about the Senzo Meyiwa trial. It is what it is, but we're here, guys. We're here. You know what to do. You know the drill. Press the like button. And then uzenge like, uzenge comment after that. And then you interact with us. If you are not a subscriber, what are you waiting for? Do the right thing. Make sure you subscribe. If you're not a member, what are you waiting for? Please join the membership. We really appreciate that. And the rest, thank you in advance.
Yes.
Right, let's get into it. Let's do what we have to do without further ado. Press the like button, however. That's all we are asking for. Emily, how are you?
I'm good. And how are you, Mr. Anonymous?
Yeah, tiring. Very tired, but I'm still kicking and bouncing like a tennis ball. Yes.
That's good.
Yes.
So, yes, guys, we're back to deliberate on what happens at the Senzo Meyiwa trial. Lately, it has been like watching the climax of a series. Just when you think, oh, everything seems to be coming down, then something new comes up.
Yes.
It's been drama after drama. Yeah, but we are keeping up. We're not falling behind. And we're not losing interest either. So yesterday, Advocate Charles MNISI asked to consult a doctor, indicating that he was psychologically affected by the claims that the defense was part of a plot to, or a conspiracy to eliminate members of the or the key role players of the state. So court resumed with Ngumalo asking to speak to accused number 4. At that time, I think it was there was someone who was late. I think it was Ramasepil at the time. Then the court register also whispered to the judge. I could not hear everything that he was whispering, ne? But the words mounted to, I just want to inform you of what I am saying. Can I just have 1 minute? 1 minute outside. Eh? Did you catch that, Mr. Anonymous?
I didn't, but yeah. I mean, these days they're loud.
Hey, those it's very awkward. It's very weird.
Those days they are very loud.
And then there was another advocate of no color there. I saw as the judge had gone outside with the court register, they went to the state or the prosecutors there, who Advocate BAYOYI and Dr. Sibanda. They went to the direction, or this particular advocate went to the direction, and he was speaking to them during that brief break. An interesting update that I got from Griselda Lewis, she said that she was told that there is an international broadcaster that wants access to film in the court for today or that particular day. And it seems like those two advocates were maybe perhaps for this international broadcaster.
Okay.
It seems.
What is that international broadcast? Is that Netflix?
Could be Netflix, we don't know. Or it could be another interested party. There are many streaming platforms these days. Many.
I mean, drama keeps on unfolding. You can't fold them. It's content for them. However, basically, I would have been interested if also I had platforms that require such services.
It's very interesting, but the fact that there's an international broadcaster interested in this drama, hey, very interesting times. Very interesting times. Well, when the judge returned, he said that he was told that Mr. Ramasipil is back, and the legal counsel confirmed their appearances. Ramasipil apologized for being late. Advocate George BAYOYI said that we don't see the witness, Sfiso Ogwabini Zungu. We don't know if he is outside. The judge asked if they did check if he's outside or not. At this point, Advocate MNISI stood up and he said he could not be outside because he was unable to attend court today. He sent a medical certificate. And the judge instructed Advocate MNISI to read it. MNISI said that yesterday he consulted a medical practitioner. The doctor says in the certificate that the doctor will also want to see him tomorrow. Tomorrow it being Friday. And according to the doctor, Mr. Zungu can resume on Monday, the 8th of December. The judge didn't look too pleased about this. And he said, what is the diagnosis? Let me see the letter. There are doctors that sell medical certificates, implying that this medical certificate has been sold.
A very serious allegation for one's profession. I mean, to actually utter such garbage in that podium where there's international attendance. See, that you are aware, that's more like gossiping. And you're not only gossiping, you are putting someone's name and practice in jeopardy.
And he even mentioned the name of the doctor.
Yes,
he insisted that the name of the doctor be mentioned. I don't recall the doctor of Miss Pinkifa in Telengem, who court had to postpone for days, because she wasn't feeling well. I don't remember her doctor being mentioned on record. I also don't remember implications or speculations being made that her doctor or the doctor she went to sells medical certificates. I don't remember that. All I remember is dignity. I do remember, though, him insisting, wanting Advocate Mgomezulu to also mention the doctor he was going to. These sentiments, we last heard them when Advocate Mgomezulu had expressed that he wasn't feeling well. And he showed the signs of not feeling well. But it seems this judge doesn't believe that people get sick. He thinks people fake getting sick. Just because he doesn't get sick, then it means everyone is expected not to get sick. We don't know what he does not to get sick. And if there is something that he does, then he must share it so that people know that they can be robots. Okay. So this thing of him acting snacks whenever people get sick is annoying.
From the defense side.
It's annoying from the defense side in particular, because when state people get sick, he doesn't throw a tantrum like this. He doesn't. He just accepts the situation for what it is and he keeps it moving. But every time the defense side people get sick, he does funny things, says funny things that shouldn't be coming from the mouth of an objective presiding officer.
That is true.
Well, MNISI then said, no, I don't know that. All of us know that in South Africa, is what the judge said. All of us. Him and who? Him and who know that? I don't know that. I go to a doctor. I go to a doctor when I'm sick. I've never had an experience or heard of anybody saying that a doctor sold them a medical certificate. I've honestly have never heard it. I've never had a personal
encounter. A very dangerous allegation against the doctors' professions. People who study
for years.
For 6 to 7 years.
And this is someone who, by the way, let a dentist come and testify, like a surgeon.
On a general practitioner's evidence.
A dentist and an orthodontist. It was there testifying about injuries and stuff. And we were wondering, we were asking ourselves many, many questions. But now he wants to discredit a doctor just because they are treating a defense witness. Well, he wanted the defense counsel to confirm that, that there are medical or doctors who fake or who give or who sell medical certificates. And he asked Nxumalo, but he was disappointed because Nxumalo this time around processed what he was saying, and that he said he's never heard of that. And the judge said ignorance is bliss, so he wanted them to confirm these rumors and speculations. If there are such doctors, then he should report them. I'm sure he knows the proper channels to do that.
He knows the door, yes. He knows the door where it's done.
There are bodies that are assigned to deal with such incompetence and fraudulent activities. So I don't think that you should be asking people such questions in a trial that has nothing to do with doctors or their selling of medical certificates. Just take the medical certificate, look at it, observe it. If you feel like you're suspicious, then do your own investigation. You don't have to broadcast it like this. At this point, we're tired.
Clouded with the doubts. As you are. I mean, that's what you've been doing, in my opinion.
Yeah, he should just keep it to himself, conduct his own investigation. Then he should do that and stop putting rumors and speculations on record. The most shocking thing happened. This judge read Gwabini's medical condition on record. The letter says that Sfiso Gwabini Zungu has a tension migraine headache. Who wouldn't have a tension migraine headache after what has been going on?
That's exactly in line with what has been going on in that court, which is disturbing for someone who's standing there to really give evidence freely and voluntarily.
And he should be glad that it's not mental distress. He should be glad that at least it's not mental distress, because mental distress is a lot more serious. It means it affects the ability for him to testify. It's just a tension migraine headache that should resolve if he gets proper rest. You understand? He's been going through a lot this week alone.
I fully understand.
So if he has a headache, he has a headache. Deal with it. Okay. Since you let police officers come to your court and do as they please, well, might as well have a headache and rest. Because what is this?
It's a lot.
It's a lot to deal with, It's a lot. Even Advocate MNISI yesterday was asking for a break to deal with his psychological well-being. It's a lot. It's a lot, Trauma after trauma, And, also him reading that record of Gwabini and actually mentioning the condition that he is asking for leave for, if it doesn't already leave or speak to the level of biasness that he already has against defense witnesses, then I don't know what will. The writings are pretty much on the wall at this point.
They are.
And he also expected or wanted Gwabini to sit there with a tension migraine headache and listen to BAYOYI as he's busy rambling, and then listen to Advocate MNISI, and then listen to Ramasipeli. That's a whole day with a headache for him to sit there listening to lawyers arguing. So BAYOYI said that he should be present when the matter is argued, depending on the inputs done by his colleagues. MNISI said that there would not be any contribution coming from Mr. Gwabini in that argument, so his absence should not be a hindrance to the hearing of these arguments. Ramasipile Nxumalo shared the same sentiments, but the judge said, okay, fine. This court differs from all your views. Mr. Zungu is a witness in this case. He's an interest. But because of protracted, which has been caused by the drama in this court, the court is going to order that in terms of Section 159 of the Criminal Procedure Act, this case should proceed in the meantime. And when Mr. Zungu comes back, the whole evidence which has been relayed in this court, together with whatever documents which have been handed up, he'll be having full access to those. But it's incorrect to say that he won't participate. That's not the letter of the law. He said, I can quote that the case of State versus Pillay, a case where there was a former Chief Justice Mpati, Motata, and Davis, a case concerning a huge robbery in Durban where they stole 34 million rands, where somebody was arrested and promised that they won't be charged, and if they complied and gave evidence for the state. He said he was subsequently charged, and he made a statement, and the police unlawfully or illegally tapped, meaning that they bugged her phones and devices, and they actually discovered that there was money at the roof on top of the ceiling. The money was hidden there. So Mr. Zungu will have access and knowledge of what transpired, and if he wants to get involved with his counsel, he should, more particularly because, if you recall, Mr. Zungu was a Section 204 witness. At this point, I was very conflicted. Who is he talking about? Which Mr. Zungu?
Because there are many Mr. Zungus.
Yes, that's where I was very confused. That
But also, it is important to note that the judge looks at the States versus Pillay 1977 case, which is probably the leading case on sentencing. Highlight that.
Sentencing.
In South Africa. So that means the judge has started preparing, in my opinion, for sentencing. That's why he's able to court such cases. The case deals with what factors a court must consider in sentencing. Okay. How personal circumstances, seriousness of the offense, and the public interest must be balanced. When appellate's court may interfere with the trial court's sentence. Do you understand? The main important thing here is all about sentencing.
But we are here talking about Advocate BAYOYI proving a statement. Kan kwenzakalani? Why not see they are quoting cases haphazardly, Jay? That have nothing to do. That have nothing to do with what the duty of the day is about. Like sentencing manje ingenapi. What is going on? Okay. What is going on though? Seriously, guys, what's going on? I'm serious. What is going on? We are not at sentencing yet. The defense has not even started. This is just the tip of the iceberg. This is just the beginning. We're not even at the climax yet. I don't even consider this a climax. We're just at the beginning. And already he's talking about cases that talk about sentencing, Mr. Anonymous.
Very, very hard to actually fathom where this is heading.
They tell on themselves, honestly speaking. Well, the judge said, I don't know whether the state is going to subsequently charge him or not.
Okay.
There's a possibility, perhaps.
Here we go.
That is why the interest must be safeguarded.
Here we start to scare people. Now, honestly speaking, why do we need to say that at the first place? How does Gwabini being outside or being at home, sick, dealing with whatever that he was dealing with, has to do with if the states would later want to charge him for being a Section 204 and being an accomplice, as they say?
Like ungenapi.
What is this resuscitating of such words and bringing back and saying it now and again? What do you want this man to do? You want him to disappear? You want him to be afraid and not come to court?
You want him to run away, not come to court?
What exactly do you want him to do?
Or you want him to what? to say that he lied.
What is the point?
What
of
do you want him
And
to
he
do?
said that not once, twice, I
Yeah, he
think, 3
even
times.
said it again at a later stage. He said it again and again and again. And I'm like, what dog whistle are you sending out? You want defense witnesses to be scared of you, or to be scared
of being arrested,
of being
and
arrested and
because
harassed,
That's what
because they
this
want to tell
court
their
has
truth.
to deal with.
They want to come to court and tell their truth. Their truth. Because it seems like the only truth that matters to the presiding officer is that of the state. The truth of the defense is not there. Is a non-binary. But it seems, or it looks like that. Because why would you send out dog whistles like that to make people believe that should they go to court, they will get arrested for testifying? What message is this sending out?
A message of fear.
And he said that is why the interest must be safeguarded. And that case pertinently says that as long as there is no prejudice, if the state recharges him now as a 204 after having given evidence for Mr. Zungu Jr., his interest must not be prejudiced. It must be protected, okay? So what is he talking about? Because ufaga no Mr. Zungu Jr. ngapha. Mr. Zungu Jr. ke Constable Zungu. What is going on?
He to me sounds like he's saying that he's already treating this witness as an accomplice to the crime, and he does expect the defense, the states, to actually arrest
him after he's
Gwabini.
done testifying.
That would be a very huge mistake and very vindictive, if you ask me.
Yes.
To arrest someone just because they came to tell the truth in court. And now another life is going to be ruined for that. It's very disturbing. Very disturbing, to say the least. It does not make sense what we are being told by this judge.
And at the same time, it also felt like he's sending out another dog whistle that Zungu Jr. must be protected. And I cannot help but to feel that he feels that Uzungu Jr. did not lie, did not get some of the things or points incorrect. He's giving out that signal from what he is saying.
What else can he give you? What do we expect from him?
And it also sounded like he's giving the state the scope again. Telling them what to do without telling them what to do. He's done that a lot. He just sends signals. So don't be surprised after Gwabini is done testifying and then you hear that either there were attempts to arrest him or some form of other thing.
It's very difficult to actually get a free trial here.
This is not a fair trial anymore. We've long surpassed that. It's no longer fair. And we cannot pretend that it is, And also, he's talking about prejudice, that they shouldn't feel prejudiced. But you read his medical condition into the record. Already that's signs of prejudice. You're not allowing him to be accompanied by people that he cares about. And I'm going to say he cares about because as soon as those people were escorted out by the police, he's the one who asked, where are the people I came here with?
Yes.
If you are going to create an impression that they kidnapped him or they are stalking him, why would he want them? Why would he be concerned
that they are being taken away from him?
So you are taking away his emotional support, and you are speaking about prejudice. Isn't that prejudice already? We've long crossed that line, in my opinion. And he says, how would you say that all of this, and as well, like, how does it happen that all of these things are just said like this, It's like he's sending some type of a dog whistle that he must be charged. And then on top of that, it's just weird. It's weird. He's sending weird signals, and and they are not making sense either, because you are treating Gwabini like he was Constable Zungu. Constable Zungu is the one who came and testified as a Section 204 witness for the state. Now, should it be that Constable Zungu lied, he will be charged with perjury, right? But now he's taking that responsibility and putting it on Gwabini as if Gwabini came and testified for the state as a Section 204 witness and lied. And because he lied, they're going to charge him at the end of this.
The mistakes, however, are similar to that of BAYOYI. And I have to highlight that, because later on in his heads of argument, BAYOYI is submitting to that extent. In fact, he's kind of saying this Gwabini must be treated as 204.
It's like they're forcing him to be a 204 witness, but the state had all ample time to do that and they didn't do it.
Indeed. That is MNISI's sentiments.
Yes, they had all the opportunity, a lot of time to do that, and they didn't do it. They closed their case without doing it. Now they want to ambush a defense witness and make it a state witness. Kanjani manje ngoba the state has closed their case. So, court continued with the state arguing its application on why Zungu should be cross-examined on an alleged statement he made to the police in November 2019. Zungu denies making that statement, but he started arguing the state's application. He said he'll be looking at Section 187 and 188, the witness to attend the proceedings and remain in attendance. Yeah. One thing I'm getting as well is he really wants Gwabini. It's like it was a thing that he didn't show up today at court, and it's like they really wanted him today in particular. I don't know, I'm getting that vibe. I don't know why, but today had he shown up, he was definitely gonna be alone.
Exposed.
He was gonna be exposed. So he said that Section 159 is for the accused person, and the judge repeated his wish for Gwabini to be charged again. He said that this status is not only for a witness. He's made a statement in Section 205 also. He said if you read the judgment of Belay, there is a possibility that he may be charged. I don't know. That's the judge right there saying all of these things. That the Belay judgment that you just talked about. And then he says there's a possibility that he may be charged. And then he says, I don't know. Kanjani manje, because you're already telling us and informing us that that's it. That's the more or less what the state should be doing. Well, BAYOYI said we have filed heads of argument regarding the application that the state wants to bring for leave to cross-examine Mr. Sfiso Gwabini Zungu on his extracurricular statement, of which you had the opportunity as a state witness. You had him, but you chose not to call him. You didn't call him at all. It's not like you called him and he refused to come. You didn't call him at all. So BAYOYI then said in the introduction, my lord, we mentioned that the state seeks to cross-examine the state witness on the statement which he had made in terms of Section 204 of the Criminal Procedure Act number 51 of 1977. BAYOYI said we mentioned that the defense counsel for accused number 1 is objecting to the cross-examination of Mr. Sfiso Zungu in his extracurricular statement on the basis that the statement had been proven. My lord, he said we will advance the argument at his own defense counsel has taken him through that process of proving the statement. Lies. When did MNISI do that?
They so wish it was a trap that did not work of bringing this statement in, and MNISI very wisely left it out. Now it is being pushed back to him again as if it happens. And you'll hear from the heads of argument where they claim that at some point it could have been used.
He gave his own oral testimony. He didn't use that statement So he said that they will prove that in greater detail during the course of their argument. BAYOYI said, we submit it's a credibility issue as to whether the statement is trustworthy, and his statement needs to be tested through cross-examination. Zungu...
It seems as if in his submission, BAYOYI is caught into two minds. He wants to use the state as evidence, but also wants to use the state as a credibility testing mechanism. You can use one. You can just take one and say, this is not an evidence. We just want to see in
and
terms
why
of
is he not
credibility.
stating it?
Because that's how it sounds like he wants to use it for two. He still wants to use it as a Section 204 statement, evidence of the court.
He can't now impose the Section 204 on Gwabini now. It's late. He had the opportunity and he didn't take it. So now you can't do that. You can't impose a defense witness and call them a Section 204 witness, and you haven't even gone through their evidence with them. As far as you're concerned, they wrote that statement and you refuse to believe otherwise. So you're coming with that mentality and imposing it on a witness who says, I didn't write that statement, and now you want to call him a Section 204. Aye. Well, Zungu was on the list of state witnesses but not called because of what Brigadier Gininda said. He said that during consultation with the state, he indicated that he was fearful for his life. He said, we submit when a witness has been made available to the defense. The position is that if the defense make use of such a witness, they will make use of a statement that he or she has made. But he's saying he didn't make it. So when Zinjani, he said that will be the whole basis of calling that witness. He said, we submit that you cannot call a witness who does not conform to his or her statement. The statement serves as a basis of his or her evidence. So he's denying the statement. Okay, he's not taking full ownership of the statement. So why are you imposing and forcing him to do that? So he said, if the witness does not confirm the statement or deviates from it, the procedure outlined in Section 190 of the Criminal Procedure Act must be followed. The statement serves as a basis of his evidence. BAYOYI said that we submit that if his testimony was inconsistent with the evidence, the defense should have followed the law. BAYOYI went through what Gwabini's testimony was and what he has told the court so far in his evidence in chief. While I couldn't retell, we all know the details, and I just felt bored because I'm like, why are you bombarding your heads of arguments with Gwabini's testimony as if it's not on record? What is going on? Is this how heads of arguments are written, Mr. Anonymous? I'm not a lawyer, but I just felt like it's like we're filling in the missing words.
He's got no substances. He doesn't have the meat that you would like to have. That's why he's all over.
He repeated the entire testimony that Gwabini gave in his evidence in chief. And I'm like, but what are we doing? I was so bored. BAYOYI then said the defense themselves have laid a basis for Gwabini's statement. BAYOYI said on his own evidence he was not coerced to make a statement, but he did so freely, voluntarily, while he was arrested on a firearm charge. He made the statement on the death of Senzo Meyiwa freely and voluntarily. Isn't it a red flag that people get arrested for different cases, but then they end up talking about Senzo? So all these people, these three people in particular, accused number 1, Moses Bia, accused number 2, Bongani Ntanzi, and now Gwabini. So all of them get arrested for completely different charges, and they just end up talking about Senzo.
It is strange.
So there's no indication that he didn't understand what was being said, is what BAYOYI is saying. And he said we make the submission that cross-examination on the statement must be followed. And he said we make the submission that we must cross-examine him to see if what accused number 1 said about him is contained in his statement. Kan kwenzakalani? So now he says he wants to cross-examine Gwabini to see if what accused number 1 said about him is contained in his statement that he denies that he made. I don't know if it makes sense because it's not making sense to me. Baloyi then said there's no indication that he did not understand what was being said or that he did not consider his position. Baloyi repeated Gwabini's testimony again and again and again. He said Gwabini Zungu does not deny telling the police that he told them. But he did. Brigadier Gininda and Sergeant Mohola to bring over what accused number 1 Muzi had written, that maybe accused number 1 did not know that he knows nothing. He testified that he asked them to transfer what accused number 1 said to the document that is now his statement. He wrote S on that statement. You know, there was a time they asked about, it was Advocate MNISI asked about Iqabani. I don't know how many of you guys still remember that. And he wanted to hammer, especially the cross-examination of Brigadier Gininda, they wanted to hammer him on whether he understands how to take a statement. And even asked him about that book. That book is about how a statement is supposed to be made and stuff like that. So he was asking him, and then he asked him to go fetch warning statements, and then he did that, fetch those warning statements to compare and to see if whether he knows how to take a warning statement, right?
Yes.
There was a reason for that. There was a reason for that, because you cannot tell me no way in any other occasion you think you can take what somebody else said and submit it as a statement of what another person said, and then you think that that's a statement and you can call that a statement before a court.
It's nonsense.
He said we therefore, and the lever to do all of this, abantu bebuka, abantu bebekile, the bravery of it all. He said we therefore, my lord, make a submission that he should be cross-examined to see if the statement indeed contained these assertions. The statement of accused number 1 to the officer Lieutenant Colonel Mboto serves before this court, and his statement to Colonel Hadebe, who conducted the pointing out, is also before the court. These documents need to be compared with the statement of Gwabini. Why?
He's
Who's
just,
on the stand? Is it Gwabini
he's
or
fumbling,
Muzi?
man. He's fumbling. He is jumping the, what do they say? You are jumping the
goalpost. What?
jumping the gun.
Jumping the gun.
Yes. He's way ahead for my liking. And he now and then takes steps back. If that is the case, what is difficult about proving the statement?
You know, we are here, Bazalwani, because he didn't want to prove the statement. And it's an exercise that will take nothing more less than 5 to 15 minutes.
Because the statement is not good for them.
Then leave it alone, okay? Why do you want to use it if you can't prove it?
But his cross-examination is based on it.
Then continue, draft another cross-examination that has nothing to do with this statement. Because all of these things that you're doing, I'm not a lawyer, but Haibo, this is so unfair. This doesn't look right. It doesn't look right on the state's behalf. Okay, no. Let it go. Sometimes good soldiers, but a good dancer knows when to leave the stage. It seems like for Advocate Baloyi, that does not apply. He will not leave the stage. He will dance and dance and dance. He won't leave the stage. So he also argued for the right to a fair trial, testing the reliability of the statement. He said that in every argument, he includes the multi-choice versus others. Guys, every single heads of argument, whether he's the one who does the heads of argument or whether he's responding, this multi-choice versus others case is always there. I can bet you, man. I've heard it so many times being quoted by the state. He says, speaking to the protection of a right to a fair trial. He said he wants a fair trial. Okay, so I'm just asking a question here. But he's speaking of a fair trial. A fair trial on whose behalf? The state's behalf. But that fair trial does not apply to the defense or the accused. Which one is it? Because he always quotes this case speaking about a fair trial, and I'm like, okay. He says there, we submit that a trial within a trial be held to determine the admissibility of the statement of Sfiso Gwabini Zungu as held by the minority judgment. The focus on the trial within a trial.
Can you believe it?
Is not
Using
on an
the
accused
minority.
guilt.
Why not the majority judgment? Isn't it the majority judgment is the one that presides over the minority?
It is. Majority presides over the minority. And you know what the weird thing is? I read somewhere about this whole trial within a trial thing. You cannot use a statement. It's mainly for confessions, is it not? And admissions. Is it not, Mr. Anonymous?
I mean, a trial within a trial. No, just in my head. No, you are wrong in how you interpret it. It should be used for any document in court, I think.
That is in dispute.
Yeah, that is in dispute.
When I was reading, I got a different idea. But maybe I could be wrong. I'm not a lawyer anyway. But he says that, but on the admissibility of the admission or confession in question, did Gwabini make a confession? That is what I'm asking. Because now when you start speaking of a trial within a trial, and you're not bringing it up for the first time, which sparked my curiosity as to, is this even possible? Where you take a statement of a person that they did not write and put it through a trial within a trial. And what's even worse is that there's no signature. It's just an S. And you are basing off of them putting an S because they were afraid of dying or worse things possibly happening to them according to their version, right? Because they were under pressure. And then you are going to put that document through a trial within a trial. That's to me is very much of a stretch. It doesn't even have proper names. Somebody's referred to as
Remember,
Zulu
they
Lule.
are saying this is statement made under section 204.
But he's,
which is mostly
if you've made a
more
section
like a
under 204,
confession.
then you should have called him as your witness.
Yes, that I agree with.
He should have called him as his witness, as the state's witness, not now wait for the defense to call him and then start enforcing this 204. You had an opportunity to do that and you didn't take it. He then said that the trial within a trial is to determine the admissibility of a witness's statement. He said relevant evidence should be allowed in order to get to the truth.
So now he's using the judge's
Methodology.
of saying that for the interest of
Justice. He wants everything. He wants everything. Everything. But you are getting versions from defense witnesses and you choose not to believe them. What is everything? Everything to debunk what the defense is saying? Is that interpretation of everything? I'm just asking for a friend. Well, Advocate Charles MNISI was next. He said he elected not to file heads of argument, but he has a submission from the bar. By the way, what an exceptional job. In fact, I could only cover his. I know Boramsipili and Ngumalo did a good job, but I only focused on this meat.
I think when he sat down, that's why I stopped.
Yo, hi, that is excellent, guys.
And we must applaud the strategy being employed here. By not filing the heads of argument and making submissions from the bar, it did not give anyone a chance to actually peruse and be able to prepare for you. And that made it even more difficult for the judge itself. Those submissions were sound and they were proper and they were robust and they were really, I would say it's like someone wrote them and he decided not to submit them and he put them aside, put them in his head because they had laws in them. They were citing
relevant
cases. So he just mopped the floor, BAYOYI, in court from the bar.
Hi. Mina, my heart was full. I was like, you know what, this is difficult. You're going through a lot. But let me say that was excellent. Okay. Seeing one of our own become, let's say, a diamond under that pressure. Because this was phenomenal. Okay. I was blown away. Well, MNISI said that Mr. BAYOYI will have to prove the statement. Then Mr. BAYOYI ultimately said, no, I propose we should rather file heads of arguments in which this aspect is going to be ventilated. Then there was a proposal about the dates and everything. When a comment was requested from me, I told the court that I still stand by my submission, that the state has got to prove the statement before it goes into the content of the statement. If they want to impeach or test the credibility of Mr. Gwabini on the basis of his statement. MNISI said by making submissions at this moment, this should not be understood to mean that I am, reneging from the initial submission, that the state still needs to prove the statement of Gwabini even before we embark on cross-examination or cross-examining him on the content of his alleged statement. And he was calling it an alleged statement. Bravo. This thing of calling it his statement, no, it's not. It's an alleged statement that he made. MNISI then said, this is what I wish to submit. The state says that Mr. Gwabini has been called or made the statement in terms of Section 204. And they had to call him as such, however, because of the information that came from Mr. Gininda that Mr. Gwabini could not come and testify because he feared for his life is the reason why they did not call him. That is now not neither here nor there.
Gwabini has really taken this case down because of such. That's why people are panicking. People are doing everything in their power, in my opinion, to make sure that he gets disturbed. All the submissions that we were told and as the only truth, Gwabini came and said, no, that's not the case. In fact, I fear the other side.
More. I fear them more because of what they did to me. Allegedly. Well, he said, I do not wish to get into that, but fast forward into their argument, the state says we could only have used Mr. Gwabini as a Section 204. And with the contents of the statement that he allegedly made, I'm still struggling to understand that, my lord. Because the minute the state made Mr. Gwabini available to us, after they decided not to use him and we consulted with Mr. Gwabini is not a state witness. Mr. Gwabini could no longer be branded as a Section 204 witness or what? Therefore, any branding of Mr. Gwabini as a 204 witness at this moment in time is misplaced. He said, when I led Mr. Gwabini in his examination in chief, the state stood up and said that it wonders if the process is proper. that I should lead Mr. Gwabini as a normal witness instead of me requesting the court to warn him in terms of Section 204. And then I said, no. Look, Mr. State, to us, Mr. Gwabini is not a Section 204. To us, he is just a normal witness. You wanted to use him as a Section 204, but for reasons that are only known to you. You decided not to use him, when you were representing your own case. And then you later on make him available to us. And in fact, to be very specific, these are the words that I used. I said you decided to use him, and we went there at the trash place. We picked him up, we cleaned him, we brought him here so that he can come and assist the court to tell exactly what happened on the 26th of October 2014. Now the state says no, the defense can only use Mr. Gwabini if Mr. Gwabini is branded by the defense also as a 204 witness. He said we did not call him as a 204 witness. Therefore, there is no such provision in the Criminal Procedure Act that, if the state fails to use a witness who they had anticipated to use as a Section 204, then when they do not use him and make that witness available to the defense, then the defense should also use the witness as a Section 204. That is pretty wrong. That will be very unfair because the status that the state had accorded to him by virtue of them having not called him has lapsed. Any person that is involved in the trial could pick up that witness and interview them. If the testimony is irrelevant to the trial, then he can request that the witness must come and testify before court in order to assist this court to come to a just and equitable finding. Now, the state had requested this court very passionately that the court should understand its plea to file heads of argument. In order to deal with this issue, my lord, now, as I was expecting, I thought that the state would come up with something that is totally out of the realm of the ordinary from the process that is known with regard to how a statement of a witness is being dealt with if the credibility of that witness is to be challenged. At some moment, I thought that the state would come up with an authority that says that no, there is an exception that says that before a witness is impeached on his statement, we don't have to prove their statement. I have gone through their heads of argument. There is no such. All that they are doing is repeating the evidence of Gininda and Mr. Zungu, which is already on record, which is true. It's just a long repetition of stories that we've been told before by Gininda, by Gwabini, by Sizwe Zungu. He said they also were talking about the interest of justice that we all know. They are also talking about the evidence of Mr. Gwabini that is already on record. But one argument that the state is missing is to come up with exceptional circumstances where a witness can be cross-examined on the basis of his statement without proving that statement.
Because they don't exist. Let's press the like button, guys. Please press the like button. Make sure you push the like button. We are close to 300. Let's push to 4. Thank you very much. Thank you in advance.
Thank you, guys. Just press the like button. So he says the issues in this case are very circumscribed. They are very specific and they are less complicated. Before a witness is challenged on the basis of a statement, that statement must be proved. It must be established. Now the state says, but Mr. MNISI, when he let Mr. Gwabini, he already proved the statement. He said, I'm sitting here and wondering, but at what point did I do that? Now I call that the state was not understanding what was happening here, because that is exactly what happened. Mr. Gwabini said that this is also in the state's heads of argument. He said, no, I was being assaulted. Then I ended up saying to my torturers, can you please transfer everything that Muzi has said in his statement into that document, and that statement you say I must make, and I will sign it. Apparently something was done. Then he put an S on that particular statement. He said, then I went back to Mr. Gwabini and I said, Mr. Gwabini, did you make a statement? Mr. Gwabini said, I told my torturers that they should rather transfer what accused number 1 said in his statement to the document that they want me to sign, and I will sign it. And I was going, with the view for them to stop the torture. I put an S there. I then went back to Mr. Gwabini, Mr. MNISI says, and I said to Mr. Gwabini, did you make a statement? Then he said, Mr. MNISI, I did exactly what I'm telling you that I did. Stop asking me a lot of questions. And then I said, Mr. Gwabini, let me tell you lawfully how a statement is being made, because that's exactly what happened. He then explained how he's supposed to have a statement taken from him by a police officer. He's supposed to explain to him his rights. He's supposed to, he went through that process. And then I took him through the steps on how a statement is made. And I remember quite vividly the court saying, but Mr. MNISI, you seem to be cross-examining your witness. Do you guys remember that? The judge interfered when he was explaining to Gwabini that your statement being taken by a police officer means this, not a transfer from another person's statement. And then I put an S. Right? And the judge said, are you cross-examining? All right? And he said, I constantly told the court that I was not cross-examining the witness. I was simply showing the witness how a statement is made. And after explaining to him how a statement is taken, I then asked him, is this what happened when this alleged statement was taken from you? He said, no. Now the state wants to use that as a basis that I've already proven the statement to Mr. Gwabini. So there's no longer any need for them to prove the statement. Kanti, why is Advocate BAYOYI acting Dilulu all of a sudden? Doesn't he know how to prove a statement? Mr. Anonymous, you said he knows. He knows.
Guys, this has nothing to do with proving the statement. This has to do with the loopholes that are there on that statement. Proving the statement, it means that he must lead Gwabini on that statement, right? And ask him questions. Do you confirm this is you?
He's avoiding that.
He's avoiding this part because it has loopholes. A big blunder that is there. The statement itself, for starters, it is wrong. It quotes Ntuli, talks about Ntuli mixing it with
Section N.
How can a person
Section N and a Section S?
How can a person who know Ntuli, as they say, they claim that he knows them, how can he
refer to
mistakenly like that? So this has nothing to with proving the statement. I think any normal lawyer would know how to do that. It has to do more with what the statement, when it's read on the record, gonna say, which is gonna make it even their case weaker.
Well, he said, I think that was a horrible misunderstanding, but all the information is on record. Now the state wants to rely on the Constitutional Court decision of Makala. Makala is indistinguishable. What happened in Makala is that Makala's brother was arrested, or there were allegations that Makala's brother and another person were involved in the assassination of a councillor in the presence of Makala. The police got that information. They approached Makala, the maker of the statement. These were two brothers, not Makala, the accused. Then in that statement, Makala, the maker of the statement, had actually implicated his brother and to some extent implicated himself. The state called Makala, the statement maker, a Section 204 witness. When they arrived at court, Makala then disassociated himself from that statement. It's like, let me give you an example of perhaps Constable Zungu hadn't been briefed or told that he's a Section 204 witness. And then after he's read the conditions or the Section 204 at court just before testifying, he then says, I did not say that. So that's an example. That's an example that I'm making. So that's what happened in this case in particular, where a Makala brother distant and dissociated himself away from that statement as soon as they told him about Section 204 inside the court. He said the trial cop said, "No, Mr. Makala, I don't believe you. You have voluntarily made the statement." But at the trial court, realizing that Mr. Makala was disassociating himself from that statement as a witness that was called by the state in terms of Section 204, then the state made an application to have him declared a hostile witness. Then court allowed that. Then the state went on to lay the foundation of that statement, which is what the state in this case should have done with Gwabini if they were serious about making him a Section 204 witness. Then he would have told his version and said, whatever is in there in the statement has nothing to do with me. And then they would have declared him a hostile witness, right? But they didn't want to do that. I don't understand these strategies of the state. I don't get them. In other words, the state then went on to rove that statement. Makala said, yes, I made that statement, but I made it under duress. And at some point, I also lied in that statement. It's not like what the state intends to do in this case to cross-examine Mr. Gwabini on the basis of his statement in order to test his credibility without having laid the foundation of that statement. Then the trial court did not find the Makala statement maker guilty, but it found his brother and the other counsellor guilty on the basis of Makala's statement, which was sworn evidence upon which they were convicted. Then they appealed to the Supreme Court of Appeal, and the Supreme Court of Appeal also agreed with the trial court. Then some wise person said, no, the Supreme Court of Appeal is not the absolute court of reference, as this matter involved the constitutional right to a fair trial. He said, let us go to the Constitutional Court. The Constitutional Court cleared the position, my lord. The Makalas were acquitted. And the judge was done, or the matter was handled by 9 judges at the Constitutional Court. So MNISI said so for the state submitting that it wants this matter to deal with it in a trial within a trial, which is unprocedural. Mr. Anonymous, I said it earlier on, and you said, Mr. Anonza, I said it earlier on, this trial within a trial, and you said it's unprocedural. You said it can't happen. Mr. MNISI brought it up. Advocate MNISI brought it up. He said, so for the state submitting that it wants this matter to be dealt with in a trial within a trial, which is unprocedural, seeks to rely on the minority judgment that says that most probably, and that was a wishful thinking, my lord, the matter could have been dealt with in the trial within a trial in order to determine how Mr. Makala made the statement and all those things.
It is unprocedural.
Because even in Makala's case, the trial within a trial, after he did that as a Section 204 witness, after he did that, there was no trial within a trial. They just continued with his statement and they went on to charge the brother. So the heads
of argument was actually created to escape the process of proving the statement, and just allowing BAYOYI to pick and choose on the statement what he wants to cross-examine on.
Yes.
Because apparently there's only one thing that BAYOYI can cross-examine Gwabini on, is that statement. And Gwabini and MNISI, they made sure that they ran away from that statement. So to now wanting to create a situation where we go to a trial within a trial with a witness from the defense side who never talked about, never read or never went through that statement, it is something else.
It would be a first.
It is something else. He just wants to create his own new ways.
And it would overrule completely this work that was done.
No, BAYOYI must just give up. You know, it seems as if he does not have.
Give up.
No, he must just give up. Honestly speaking, look at it. He's just stretching things, man.
Yeah, but not if they had just accepted grace from the very beginning and dismissed the case. You know?
Hey, now it's difficult.
Hey, now
it
it's
has
difficult.
costed us money because now questions are going to be asked. Now you need to close it in the right way.
Even now it's going to be difficult, Shem. It should have just happened with Maumela to say that the law that I know, evidence, what, you know, just let it go through.
When you try to marry these things together, now Shamila Batoying is squirming, trying to attack or trying to take Chauge out. A person who refused to actually persecute this thing, and it was looked at as this
As a
bad
thing.
things.
He was villainized for it.
Yeah,
People
well,
are like,
now it seems as if
Nini
it's being
Bonile.
vindicated.
Bonile ukuthi uBatoyi uthini? Uthi yena bengamcross-examine. She's saying that she did not come there to be cross-examined. She came there to give evidence. Now, bo advocate Nkabinde bayabuza laphana ukuthi when did I ever make such a statement to you that I will not cross-examine you? Yay! Kubi. Like, I don't know. Like, the NPA, hi, con, hi, shubile ngampela.
The loopholes are visible.
Hi.
I mean, people are doing things that are unheard of.
And another thing that she also allegedly did is that the Katomena killer squad there at KZN, there was the boss or the person that ran it was also acquitted of the crimes that they were being accused of. So their case went away, right? And it's being alleged that the NDPP is the one who did it. There's an allegation. So it's a lot going on over there. There's a lot going on.
That's why he's afraid of being cross-examined.
Agafuni. And then they were also asking about the statements as well.
He wants to
That-
nitpick and say,
She wrote statements without going through annexures, but she's referring to the annexures in her statement. And then Bayambuza, you didn't go through the statement before you came to testify. Yo, guys, it's a mess. It's a mess.
so it's like someone wrote it for you,
Hey, Batung. Yay.
allegedly.
Uyo testify. And you know what the weirdest thing is? She's the one who came up with this inquest. Oh, hey, kwaze kwaba tough. She's the one who launched this inquiry into Advocate Chauke. And now she doesn't want to be cross-examined. Statements, hey, but I don't know what to say. I'm so speechless. Like, what? Now it kind of makes sense. Even with Senzo's trial, the way that it's been going, the dots are starting to connect that kwa NPA nje hai
It's a mess.
asiyabuya kwa NPA. Nobody's holding anyone accountable there. Akuna accountability, none whatsoever there. Well, he said, but the majority of the judge at the Constitutional Court had to consider the aspect. They did not even deem it necessary to mention it in their majority judgment because they know that would have been unprocedural. The only procedure through which a witness can be impeached by referring to the statement is simply establishing the statement. This is what was said in the judgment of Moses versus the state. It's a Northern Cape decision in Kimberley. The judgment was delivered on the 18th of September 2023. This trial started in 2022, the same time that the Senzo Meyiwa trial started. By 2023 September, they were done. Moses. Well, Nisi said we can file heads of argument from morning to sunset, from January to December in so many pages. There's only one bridge that is supposed to be, crossed. And it is that bridge which is on state versus Govender, which was approved in the case of Muzi versus the state, my lord. Nisi also spoke of the section 190 that the state referred to. He said that section 192 also speaks to the process. He read that section 192 from his cell phone. And Nisi also hammered on the state leaving out that Gwabini put that S because he was assaulted. Notice how the state always says he took ownership of the statement by putting that S, but they don't want to acknowledge the allegations of assault. They want to act like they didn't exist, they didn't happen, or he's lying on that part, but they want to acknowledge the S and say, okay, fine, he put the S there, so it means he acknowledged the statement. But they completely ignore everything else. Even with their confessions of accused number 1 and 2, they did the same thing. So the fact that Gininda said Mr. Gwabini was afraid of testifying because he was afraid, that is what the state says. He reduced all of it to hearsay, and the credibility of that information depends on what the originator of that information will come and say. Gwabini said that they are lying because he has been Viva Voke, because he has been so they hired, he said they called him 3 times to his offices. He went. In fact, he had to use a hired car on his last visit to the state, the prosecutors. How could a person who was fearing for his life had done that, that is being peddled here in court, in a sense that he's lying? He said that they are the ones who chase him away in all instances. So the procedure is simple. Prove the statement, establish the statement, and then proceed to do whatever it is that you want to do with the witness. Nisi said, I would submit that the state has come up with nothing new. The state has not made any submissions to make an exception to the rule, that which is to prove the statement. Siyabonga. Yes, Ramasipili and Malo also put up a good fight, but I was content with Nisi.
Done.
Everything that was bothering me
Signed,
was covered
sealed,
here.
Submitted. Done. You can then go on and find your own things because you are interested in whatever you are interested in. It's okay. But in as far as the submissions were made today, MNISI squash everything that BAYOYI stands for.
Black excellence.
Black excellence. Let's press the like button, guys. 332. That's half of the people that we have here. Please press the like button. Let us reach that 400. We are pushing ourselves. Don't forget to do that to assist this channel. We appreciate you in advance. We thank you in advance.
Is it time for phone calls now?
Yeah. We're not even gonna go to the others, ne?
I'm not.
You're saying no. Right, let's hear what people are saying from their side. Let's hear what you guys have to say. I suggest this is yesterday. This was yesterday. Okay. Yeah. Morning family. Those guys who were in court who okay. Okay, yeah, no, yesterday. Let's hear what you guys are saying. The number is 071-153-7006. That's the number for both WhatsApp calls. And let's hear, just short, guys, to give others a chance so that we have maybe a lot of people coming through. Getting to the point, say what you want to say. Give her a chance. Mzansi, hello. Yes, how are you? Okay.
Okay.
Person dropped. Let's hear another caller. Why they are fixing that. let's hear other people. Not worth going through them, Mr. No, that's Laura saying. It's not worth it.
If we had time, then maybe I could have. But in a corner, my heart is full. My heart is so full. I don't want to lie.
Let's hear what you guys have to say. I see someone saying, please give us the state versus Mark summary.
State versus Mark.
Okay, let's see. Let's take the call. Mzansi, hello.
Hello, Anno. Hi, Emily.
Hi.
It's Madod in Cape Town.
Yes, Madod.
Amalanga wafani, but
Yeah.
Amalanga wafani. No Mr. Babene visitor ekuseni yabe seyanyamalala ke nengi maphoyisa bese asanga siwabone namuhla. The lies have a short legs.
Yeah.
You can do whatever, but only at a very later stage you disclose. Advocate Numalo says the law is not a mathematics. 1 + 1 is equal to 2.
Yes.
The law has the authorities.
Yes.
Even our judge, it was lost. I feel shame for him. Otherwise, I'm glad what those guys they doing. Mr. MNISI today, he reminds me Nkomezu. I believe MNISI, he have experience more than Mr. BAYOYI. Mr. BAYOYI, I believe he go on the multiracial schools, so that but when you follow him, there is nothing on him. Otherwise, I'm glad. But after this witness, this case is finished because of the 2 witnesses. These 2 witnesses is the witnesses they use to support Constable Zungu, what he was saying. Remember, those people, they don't have any eyewitness, they don't have anything. They only have these 2 witnesses. They support Mr. Zungu, the constable. So these 2, they did everything, which is there is no case according to this case. So, Mr. Zungu, the meeting, it was place. They never be there. This man, we were going together since 2008. I saw him up to 2017. 2014, we were drinking like that, which is Mr. Constable evidence. He's going to the train. Without Constable Zung, this case, the legs of Constable Zung is these 2 witnesses, which is those 2 witnesses they deny, which is there is no something called Constable Zung. I believe it's what I think. Thank you very much, Anna.
Thank you.
Good night, Emily.
Good night. Thank you so much for calling. That's pretty much it.
The state versus Mark, the calls are still open. The state versus Mark cases like Mark are often invoked when the prosecution's case depends heavily on accomplice testimony. It guides the court, especially appellate courts, on how to approach the convictions based solely on largely or in single accomplice witness, not prohibitively but with the caution for the it's this case is just a mess for me. For the defendants, it means that just because the evidence is from an accomplice, it does not guarantee acquittal, but it opens the door to challenge based on lack of corroboration and contradictions on unreliability.
That would make sense in a case where there were no witnesses. This case has witnesses.
Yeah.
It has witnesses. The people that were in the house. We're not going to treat this case like it has no witnesses. Those people that were in the house are the people that this case should have begun with. For them to come as state witnesses, all of them, and testify.
So basically, he's saying that the cautious but collaborated accomplice testimony can suffice to convict an accused. In other words, what they're saying, if there's only one accomplice providing evidence, the court may convict, provided the testimony is carefully weighted, properly collaborated, and the court applies caution as required in such cases. The decision confirms that the single witness accomplice evidence need to be automatically rejected, but must be treated with caution, treated consciously and tested against collaboration or other evidence. I feel like this is the case they were relying on to really take these guys down.
That's why
they were talking about wedding. Were you there in the wedding, not there in the wedding? So the promise is probably going to be broken, because what Kwabini is doing is to rubbish everything that is being said here.
They want to make him an accomplice. An accomplice to what? An accomplice to what? Because right now as we stand,
this is what we call
those people are not even placed by hook or crook. And you have confessions that you are standing by, and you are saying that these confessions are legit, and yet you still need an accomplice. When a person has confessed, usually...
So the judge was going to rely on this to convict these people.
Change of plans.
It seems as if things are changing now.
Change of plans, change of strategy.
Seems as if things are changing. Things are not nice. It's not nice. Here it's not nice, Bob. That's what is happening. It seems as if, it's not nice. The calls are open, guys. Let's hear what you guys have to say. Mzansi, hello.
Mzansi, hello.
Yes, sir.
Yes, sir. You will forgive me, commissioners. Don't hang me. You will forgive me.
Okay.
Is everything good? I hope everyone is good. Up here is now getting cold,
Yes.
Yeah.
And you are now doing things at night, becoming harder and harder.
Yeah.
Yeah, but anyway, thanks you guys for giving up the good job. And I do not know, since we are all going to the recess, if we are going to do something about going back and summarizing things.
Yeah.
That has just happened the last half of the month, because I think the things that just happened are the problems that we are having.
Yeah.
We need to review it, because we did a good job by reviewing Absalom Zungu's evidence.
Yeah.
Like sometime this year, I think it was July. I think we should go back and revisit. Because I think the problems we are having, these problems started this year, somewhere around June, July. Because something happened, the state moved so fast. So fast, faster than the way that they haven't moved. Because all of a sudden, we had people in helicopters taking pictures. All of a sudden, people are inspecting local, like moving so fast, like we just didn't understand like what was happening.
Yes.
for them to move that fast, swift for the defense, I know. I feel like we as in Mzansi reality have to go back and summarize those times, because I think if you summarize it right, you will get the answers there. What happened? Because everything just happened so fast, and then they just closed the case. Like, no, we are not going to touch anything again. Yeah, because that's what we are having now. That now the state sees that no. The direction MNISI has taken, they did not see it. Now they are trying their best to do what they do. But since we are all familiar with the state, we know that they are not going to say anything that makes sense. They just want to say something so that guy comes the next day and say, no, let's put this thing on record. Whether they say something that makes sense, no. You know the answer that is going to come. So we are just listening. That's what I'm saying.
Yeah.
You're listening to the state and it talks from back and forth and you get confused. Like, where is this state going? But you cannot say anything because people are going to say, no, the judge is biased. But we are past that stage now.
Yes.
We went past it. We've been here 5 years. So we are not talking about corrupt people. We now need to review what went back in that May, June, July period. We need to summarize it and that's a reality to get our summary, because now if we miss that summary, we will get lost next year. Something is going to come up. So that's why I'm saying we need to find out exactly what happened with Mkwana. That thing happened. That people started going to inspection in local, taking pictures in helicopters. Too much nyaga went on there. That's what I'm saying. If you're going to summarize it with Tumisane's Kumalo's evidence, because too much nyaga went there. Because that's what I'm saying. In Kumalo's evidence, it comes up with names. Because I think those are the times that operations also happen for those KKTD.
Okay. That's homework right there.
Kumalo thing. And summarize Kumalo when he came back right now, Kumalo.
Okay. No, thank you.
So we can get it, because those were the times of those Johannesburg arrests, those hawks and stuff like that, people in helicopters. That's what I'm saying, that we need to go back to that time, because that time happened so fast. The judge all of a sudden agrees for an inspection in local. Without question.
Sorry about that. We just had connection issues. Mzansi.
Allegedly.
Yes.
Yeah. Yeah.
Imali sisihle ukuthi inkukhu ufuna ukuyibamba uphosa imigalazo. Ngibuka unqumalo laphaya uma ekakhulukazi ngizophawula le nkathi unqumalo akubuza yena kuthiwa unqumalo awazi yini ukuthi leli lizwe udokotela bayathengwa yini. Ukuthi angikwazi nalokho ngiyaqala ukubuza. Engizokusho nje mina sishana ukuthi ikhosi yethu uma ufuna ukuyibamba kahle izobheka phansi. Ikhona the law. Ikhona the authorities. And ilaws ikhosi izobheka phansi. Ukuthi ngikhohliwe nje ekugcineni lapha sebeqede bonke abo-3 ama-defense ukuthi itheni icourt in terms of proving and stuff.
Sebo. Right. Keep on calling, guys. Hey, network namhlanje ngathi yala bafowethu. Hey, the golf report is not coming. How? It's not coming la. Someone is saying the golf report is not coming. Hey, angazi kwenze njani ukuthi kwenze njani ama network kwenzelani something, but network ngatial. You can hear even some of you are breaking and all that. But yeah, let's hear. Zanzi, hello. Zanzi, hello.
Hi, Mitano and family.
Hi, how are you?
I'm very well, thanks. Mitano, my comment was, I know yesterday people were saying a lot of stuff about advocating me.
Yes.
My comment was, I hope people realize that this case, it rests in this one.
Exactly.
Because you could tell from the argument that he did not even have to prepare anything in writing. It was straight from the bar and it was on point. Yeah, and then I'm not saying Numal or I'm still not doing anything. No, I'm just saying you compare the three of them. You see, Mshololo was not even there.
Yeah.
And yeah, so I'll give credit where it's due. Advocacy was on point. And then my second point is, I don't get it. I'm not a lawyer, but I don't get where in a situation where BAYOYI, he had Gwabini as a second 204 witness, and then he decided not to call him. And then he is now falling to defense, and now he wants to revoke Section 204. Why? You should have just revoked it and declared him a hostile witness on his part so that there is no chance of this one being called by defense.
Yes. That would have been the best defense.
That could have been the best. Now, he is now going back to, it's just that I don't trust the judge. So the judge might come and say, okay, let's read the statement, we take it as it. I don't trust the judge. But it to me doesn't make sense. It's like you are being the ref and you are also a team playing at the same time. Because you're like playing both sides. Like I didn't call you a part of my state witness. I can still use the same rights when you are now a defense witness. So, and the argument from BAYOYI, I didn't even pick anything about proving of a statement.
Yeah.
Through the submission of those, I didn't pick anything. It was just wishy-washy everywhere. You even got a case that was overruled at Supreme Court. So it's not an authority then, because what was discussed on whatever laws we got, something. It's not correct.
Yeah.
But I'll give credit to Mr. So yeah, thanks.
Thank you very much. I guess in Australia the lines are just straight. Press the like button, please. Press the like button, and yes, keep them calls coming. Zanzi, hello. Zanzi, hello.
Hello.
Hi, sir. How are you?
Good yourself.
Good.
Morning, Emily.
Morning.
You know what? I've called in to first give you guys your flowers.
Okay, thank you.
And I want to know why. You know, I think I was engaging with Emily on the commentary section.
Yes.
You guys emphatically predicted that BAYOYI will not prove the statement, but will take a different turn. I could see that, but I couldn't believe that BAYOYI will actually literally go against what the court said he should do. So the question I'm asking you by giving you flowers, what made you guys see that? Because you saw it very, very, very clearly, or this guy is not going to approve the statement. He will take his different turn. So I'm asking, what informed you guys to see that?
Because to traverse that way, it's dirty. It's really dirty. It's very dirty. Like to actually go on, read that whole thing on the record. It's dirty. You just want to nitpick it and say this and that you want to say, but everything is throwing you under the bus.
True. And you know what?
The state's case.
Yes, for sure. And I think MNISI really played this very, very well. Yes. You know, this case I feel like it's very simple, because there's no way one can run away from the truth. It's very simple for a good attorney to really win this, because there's just nothing really on this case. However, and that's why I would say, you know, a brilliant lawyer will not, lack of a better word, will not pass up to this case. He will make sure that they actually bury it, like what MNISI
and team are doing
by
simply calling those two witnesses. But you take a nonsense an attorney who can't think, like basics of thinking. They would have easily folded to the state for what BAYOYI is doing. Because BAYOYI simply is just quoting things out of context. He is lying and really hoping that let them be stupid enough not to see what he's trying to do. And hoping that the judge will also help him. So in a simple case, however, it needs someone who is really brilliant, who really knows how to pay attention to detail, like MNISI, to make sure they bury them. So for me, to be quite honest, the case is done. What Baba Zungu and Gwabini have done or will do to this case cannot be undone. They are gone. They are gone.
They are gone.
Then lastly, my last point, I feel the judge was trying to give some points as he usually does to the state, that had you guys actually touched him when you saw that this guy is not willing to come and testify for you, had you guys touched him, it could have helped you so that you put him there against the accused, then be cross-examined, then even a trial within a trial because you have been an accused.
Yes.
However, I think because obviously he doesn't know much, doesn't know that actually the state doesn't have nothing to charge Gwabini with.
Yeah.
I think he's really trying, even with this case, Yamake, because his comment at the end was like, you guys will go and do your homework and do in this case. It's not about just proving it, but we need to look at the totality of all evidence.
Yeah.
In my mind, I think you are trying to say that, you know what, I could actually rule in favor of you, BAYOYI, by saying that we don't need to prove any statement or prove anything. But me as a judge, having seen totality of all evidence, can I say this guy can be charged?
Yeah.
I've got a feeling that he's giving them a leeway for them to win this. However, I don't see it happening at all because the judge would be very crazy for him to go that way. Anyway, thanks, family, for bringing analysis once more again. Yeah.
Thank you.
Sharp.
Zanzi, hello.
Mr. Arno.
Hi, sir. Hi, Miss. Hi, how are you? I'm used to say.
So unusual.
Yes, I'm good. I'm used to
We're not used to female voices. When we hear one, we're like, oh, welcome. It makes us so excited.
Yeah.
Just transfer what my brother has said.
Yes.
I will sign it.
Yeah.
What we are expecting from that statement, should the judge admit that statement must read, I, Muzi, Kaukulelwa Siya. I know that Makimba and Marco are the one. If that statement is not saying that, it's not the one. Remember, because Mr. Gua is saying to us, I told them to do the export and import business when making a statement. Do not write anything. I did not say anything. I don't know anything about goalkeepers. I know nothing. So my brother, I suspect he was not aware that I know nothing. Just transfer. Stop this torture. Take whatever Makimba and Marco is there. Put it here. Let me support my brother. And put my S. So if the statement that is going to be read is not saying Makimba, Marco, it's not the one. Because Mr. Guap is not saying anything at all. Mr. Guap said export and import. when you are writing the statement, just transfer. So we are waiting for the transfer to the judge. Admit or approve whatever Mr. Baloyi is asking. Makimba, Marco must be there. That's what we're waiting for.
Yes.
Thank you.
Thank you.
Thank you for that point. Yes.
It's a very difficult road for the judge. If they accept it, they now have to deal with that mountain to say. But my brother talked about Makimba, and you did not write anything about Makimba. And I did not say what you wrote here.
You say, I, Moses B, said this and this and this and this and that. Not Gwabini Fiso. I, Gwabini.
Let's push one more. Let's push the like button. Press the like button. 400 is close. Let's hear what you guys are saying. Don't give up. I know you call, and then the lines are, at the time when people call, the lines are busy. But keep on calling. Let's see what you guys have to say. There's a number that has been calling here. Because I mean, but most of the time you call while someone's still on the line. Let's hear what you guys have to say. Press the like button. We are close to 400. Couple of likes, then we reach 400. And then we're pushing for 5. Yes, we have. Let's see what you guys have to say. Yes, here we go. Zanzi, hello.
Time when people call. Hi, Mr. John, how are you?
I'm good, sir. How are you?
Hey, I'm good. You're speaking to, let me not say my name, but
yes.
I'm calling you from Mpangi.
Oh yeah. Yes. Mbangweni.
Yeah, Mbangweni, yeah.
Yeah.
No, man, ngithi mina mhlambe one might say abongo baba MNISI.
Yeah.
Yeah, because the day before yesterday, I felt it. I felt it.
Yes.
But ukumbona namhlanje kungenze ngaba ngcono kakhulu. You know, uma ngabe wazi imudi yalaba bantu abadlala eHollywood.
Yeah.
In 5 seconds, chinja ka 5.
Yes.
I was in that situation. So nje siyambonga kakhulu MNISI ngoku-addressa nje ne-court from the bar. It was very brilliant.
Yes.
It was brilliant. And I was going to say ama-points lawa kade eshiwile sisi usho exactly nebekade ngithi ngifuna ukuyisho. And if you can correct me, didn't uGabadia said uGwabini washona?
Yeah, but you know, there's that theory. Maybe we can need to go back and but listening to Gabadia is very painful.
Yeah, he said that, and the judge was asking for a death certificate.
Yeah, it's very
and
very
the
painful.
answer was not clear when it comes to this.
I remember something like that.
Yeah, the answer was not clear when it comes to that. And they were promising that maybe they gonna bring the death certificate. Yeah, you know, Ukabadia, when it comes to Ekotene, he's a very number one. He's very good.
Yeah,
so hey guys, I keep up the good work. And Mr. Anonymous, yazi ukuthi indlela ogesa ngayo and ugesa izinto kuyizona, because you guys said that uBaloyi will not bring any new heads of argument.
Yeah,
you said it. Hey, keep up the good work, guys.
Thank you.
There was nothing new with those heads of argument.
Yeah,
boring.
Spong. But it has been, it's difficult to go through these things, but we will try.
Good morning, Mr. Anonymous and Emily. You see, he's trying to play a game that he will not win. Because now what he needs to do is just to prove a statement. We don't want a trial within a trial because of the court. It's going to go on session sometime, hopefully, I think by next week, if I'm not mistaken.
Yeah.
And we want Gwabeni to finish his testimony so that when we come back from recession, the case proceeds to other witnesses. But by the look of things, there's nothing in this case. And for Gwabeni, there's nothing he must be charged on because of, should BAYOYI had been called Gwabeni, he could have declared Gwabeni a hostile witness. But because of he thought that Gwabeni is going to mess his plans, he didn't call him.
It was going to be the best defense to, it's like blackballing Gwabeni so that nobody touches Gwabeni. Mzansi, hello.
Good morning, Mama.
Hi, sir. How are you?
How are you?
Good.
Yeah, very well. This Emily.
Hi.
How are you?
Yeah. Good.
No, yeah, no, 2 cents anyway, starting from ill health. Considering he witnessed the hostility, there was Upinki. When Upinki was having a cold, I think we were so sympathetic, and she was given, I think, 2 days of first aid to go and recover. Yeah, and just wonder with that, why is the judge so inconsistent with the locals? And now even Gwabeni, we can't even differentiate whether he's an accused, whether he's a witness. Now in his mind, it seems he's not differentiating the two.
Yeah.
Then just moving on even to BAYOYI, which is quite laughable anyway, which is what he's trying to do, like you are saying, which is not being clear whether he wants to trigger the 204 or he just wants to pick. I think he's just wanting to be on the fence. Whatever falls, then he sticks to the other or whatever. He doesn't want to let go of any of those so that he has 2 options. Then at least he has something to hold on to from where I stand. I think he's just holding on to that. And of course, I'm in the head of arguments, like everybody is saying, there was nothing new and there's really some difficulty. And with the way Gwabeni was treated when he was arrested, I think they never imagined him coming. That's why he was pushed to the side. They thought he would have been fearing with the defense as a defense witness. He would fear coming in. So they really didn't imagine him coming. So now it has really taken them to another level. And I think the recess can't come any quicker. So the disturbance now of this week, I think it's just seeing the recess approaching to get some time to go and re-strategize. Is my suspicion, because this week there was like an element of really trying to disturb in the proceedings and push it to the defense side to make it as if the defense or the witness is being hostile and whatever. But I think it was pushing things to the recess. We are re-strategizing.
Yeah.
Allegedly. Yeah. I'll leave it for others also to contribute. Thanks for the opportunity.
Thank you. Thank you. Injalinda. I think here we have let's see.
The statement of this witness is very crucial, my lord. We're going to ask him very important questions, my lord. Simple thing, just prove the statement, BAYOYI, and move on. That's all. This guy is counting sugars now.
Yeah, it's difficult, eh? Difficult. You're put in a corner. Let's press the like button. It's difficult. Someone is saying, will I be profiled if I attend that tavern? Just asking for a friend.
Griselda reported that yesterday, what did she say? She said that they were given different bands. So it seems like there's something that they give to identify. So there's different colors for media, there's different colors for the lawyers, there's different colors for people at the gallery. So a lot is going on. Now it won't be as easy to attend like it was before. But you can always,
try your luck. if you have a bail, if you're a lawyer that can bail you out, try your luck, man.
Yeah.
We don't know. Us about you come back and tell us about the experience. But you must have a very good lawyer on a speed dial, because next thing someone comes and whisper to you in that court, and then we see you, we hear stories that you were 20 of people that were there. They caught you. You never know, man. There's a lot of things that are happening in that court.
As you hear, but they vanished.
Through thin air, no camera, no nothing, no pictures or something. They just vanish.
Next thing you'll also attend and then told to go outside, and then but you vanished.
So if you want to test your God or your ancestors, you can go there, see what will happen. If you want to see how lucky you are, some of us who know that we're born on the bad side, sometimes we don't try our luck. It's such as that. We don't. Mm-hmm. We stay far.
Stay far away from that.
Far from Pretoria. Far from Joburg.
Far away.
Something like that.
Far.
Yes. So if it happens that you go there, tell us. You mustn't be calling us at Sun City next thing. They've caught me for nothing. We know that story. That's what we will say. We know that story. We sort of told you yesterday. But yeah, don't. I wouldn't advise you to go closer.
Don't go.
Next thing you say, this one of Mzansi is a spy. Yeah, this one used to call Mzansi. Next thing, our phone is taken for assessing, for intelligence. You know that intelligence. Then it comes back with calls that cannot be explained. And there's a blade. Press the like button, guys. Please, let's press the like button. Thank you very much.
Okay, guys, thank you so much for this wonderful show that you've just given us. Until the next one, it's a bye from me.